Welcome back, America. I'm Hugh Hewitt. Andrew C. McCarthy is joining me. He is, of course, a National Review columnist. Andy, my 1 year at Justice, I spent basically as a messenger boy from the FBI senior agent on the fifth floor to the Attorney General with FISA applications. So I had all the clearances and I read all the warrants, but I was just a messenger boy, errand boy. I know that the FBI then really operated sort of solo, but within the DOJ. What authority does Pam Bondi and the president have over individual agents and agents in charge in different area offices?
So it's a very untested area, Hugh. I wrote a two-column series over the weekend on the cases that I think will bring this to a head, which is the removal of the inspectors general. But beneath that, I guess you probably think the same way I do, like everything bad that has happened in America in recent history all happened in the 1970s, and most of it after Watergate.
Yes.
And you get a lot of legislation coming out of that period of time. I think we've talked about this before. Today we're going to talk about yet another one of these statutes, which is the Inspector General statute, and also the statute that creates civil rights or civil liberties, not civil liberties, but civil service protection.
And the Civil Service Reform Act of 1978. I ran OPM at the end of the Reagan years after being its general counsel, so I know that stuff pretty well. Yeah.
Well, but here's the thing, Hugh. The Supreme Court, and I think the most brilliant illustration of this, obviously, is Justice Scalia's dissent in Morrison versus Olson, yes, the independent counsel statute case. But the collision we have here is that the Constitution, as Justice Scalia explained, reposes all executive authority in one official, the president. And to me, that means the president, since he is everybody in the executive branch, whether you're the Secretary of State or the student clerk in the Justice Department, everybody exercises the president's authority. And it's an ineliminable component of having authority like that you can remove people. The Constitution requires, with respect to senior officers, that they have to be nominated by the president and confirmed by the Senate. But with respect to removal authority, the president should have removal authority, not just over senior officials, but everybody in the executive branch. So the pushback on this is that the executive branch gave that away in the 70s when Carter signed off on this legislation that you just described. But of course, if it's the Constitution, the executive can't give away its authority. But I think it's a very untested area of the law, what the extent of the president's removal authority is with respect to people who have civil service protection under that statute.
And even if we go with the solar system approach to civil service protection, the sun being the office of the president, the executive office of the president, the White House, they come and go at his pleasure. And then you go out to political appointments and advise and consent appointments. But then you get out to lawyers at DOJ. Those are Schedule A as opposed to Schedule C appointees. I think they can be removed. I don't know about FBI agents. I don't recall. But it's awfully hard to fire a secretary at HHS or a G8 at HUD. It's really hard.
Yeah, so I think this is proceeding on two tracks, though. So on one track, if you're going to have the constitutional argument, let's have it. And let's define what the extent of the president's authority is. But I thought the executive order that President Trump signed on his first day back in office does not try to grab all of that authority, even if he has it. What they try to recognize is a more middle ground, that it's not enough if the president is going to move executive branch policy to have removal authority only over top officials in the executive branch. You have to widen it out to people who make and implement policy. That still leaves most of the, how many million employees there are in the executive branch. We're still talking about just like the top couple of tiers of the executive branch. But if we could define that the president has that authority, that's a major move forward to reestablishing constitutional order in the executive branch and to crimping the administrative state.
And I noted in your first, and stay with me for the break, would you, Andy? I noted in the first
Sure,
of your two pieces that the IGs did not come with any statement of whether or not they could be fired because they didn't want to trigger that. They didn't want to trigger the constitutional test. And I think you're right. And that's a terrible statute. And I know Chuck Grassley loves them, but they're just awful. They're slow. They get in the way of actual lawyering. They don't get anything done. And you got to go read Andy's two pieces at National View. I'm back with Andrew McCarthy. Andrew, Judge Webster was running the FBI when I was at Justice. I'm still in awe of him. I get to see him maybe once every couple of years. He belongs to a group of guys that I occasionally drop in with. And he's 100 years old. He's an amazing guy. He went on, ran the CIA, and he was a federal judge. Really good guy. I've never met a bad bureau person. I know that they exist because one of them sold our secrets to the Soviets about the tunnel under the Soviet embassy, all that stuff. But when you worked with them, what's your impression about the Bureau and what's going on at the Bureau right now? Because I think just there's a slice of politicization, but 90% of it's great.
Yeah, I love the Bureau. I worked with them for 20 years. But let me give you my thumbnail of what happened to the FBI, Hugh.
Okay.
I think that beginning in the 1990s and certainly after September 11th, the ethos of the Bureau changed. So the Bureau's strength is to be a law enforcement agency that has a domestic security sideline. I believe that after 9/11, they became an intelligence agency that has like a law enforcement sideline. And the problem with that is it's a totally different ethos. You know, if you think about it, the reason the Bureau is our domestic security service is we have to have that handled by an agency that is under American law. Whereas most of what intelligence services do overseas is actually against the law. Espionage is against the law almost everywhere.
Everywhere, yeah.
So it's a very different ethos, and importantly, it's a very different skill set. And I think what the Bureau was always good at was cops and robbers stuff, especially forensic solving of crime. They're peerless as far as that's concerned. I think after 9/11, the character of the Bureau changed. And when you're when you're primarily an intelligence agency rather than a law enforcement agency, it seems like it's incumbent on you to take liberties because you're always justifying what you're doing as saving lives and national security. Whereas domestic policing is very different. We're trying to manage crime, and people have rights, including the presumption of innocence.
I hope, Andy, you will consider writing a memo to Kash Patel in the form of a column, because I don't want to mess up what we need. They do serial killer profiling. They do hostage rescue. They do bank robberies. They do kidnapping. They do a lot. They also do espionage pretty doggone well. I mean, they knew where the bad guys were and they followed them. They didn't arrest them. But golly, it's broken.
It's broken, but I don't think it gets back to what it's good at unless you look yourself in the mirror. I'm not as big for them as you are, Hugh, on the espionage stuff. If I had my druthers, I would take away the domestic security mission and give it to an agency that only does intelligence, no police power, and I turn the FBI back into a police force, which is what they're good at.
Well, that's a beginning. That's a statute, not something Kash Patel can do, but it's a good idea. Andrew C. McCarthy, follow him on X. Go read his two-part piece at National Review on challenging, pushing up, where the Article 2 authority begins and where Article 1 ends, and Article 3 ought to avoid. Thank you, Andy.
Thanks, Hugh.